Morning. I'd like to welcome you to the latest Affordable Housing Professionals of New Jersey webinar. My name is Ed Schmear. I'm the president of the organization, and I've been asked to moderate the program today. And I think we have a very interesting forward-looking program. The title, Where Are We Now? And I look at the future concerning New Jersey affordable housing. Driving in this morning, two things hit me. One, next Friday is July 1st. And I guess that really starts a countdown of 36 months, believe it or not, before July 1st, 2025, when the fourth round obligation for all municipalities will be triggered. That's just around the corner when you think how long it's taken many municipalities to accomplish or begin to accomplish their third round obligation. 36 months is going to blow by pretty quickly. So the future really is here. And I also thought of a group, Fleetwood Mac. I'm one of the old guys and I enjoy Fleetwood Mac. And they got a great song, Yesterday's Gone. Don't look back, yesterday's gone. Well, I think we could almost say that about the current obligation to address affordable housing for the third round, where it's a set 10-year cycle, as you know, and we're now, entering the tail end of that cycle. So we really should begin to focus forward, and we have a wonderful panel today with a lot of experience in order to do so. So our first panelist this morning is Josh Bauers. Josh is an attorney, and many of you probably know him, with the Fair Share Housing Center. He's been with the center since 2015, and he has been busily working with municipalities throughout the state on their third round compliance. And with that introduction, Josh, if you could open the program and deliver your comments. Thanks.
Thanks, Ed, and good morning, everyone. As Ed said, I'm Josh Bauers with Fair Share Housing Center, and I've been asked to sort of give the roundup of kind of where we are with the third round, especially with the declaratory judgment cases, and maybe with a little bit of a look going forward. And I think we're also gonna, all join later for some questions. So as things stand right now, we have resolved every case via a negotiated settlement that was filed in 2015, except for one. There's one town that's still hanging out there that we still need to negotiate to a resolution, but all the others that were filed in 2015, and that's about 340 of them that filed in there, somewhere around 2015, that we have resolved. There are some towns that filed after 2015 that we've also resolved, and there are a few that filed cases more recently that we're still working on. But as far as the now the older cases go, we're almost through all of them, and I think that's that's an important milestone and number to keep in mind, is that I think that in this third round process, this is really the first time in basically 20 years or more than 20 years at this point where we've actually had, statewide broad-based compliance with Mount Laurel, really with COA having, really starting to falter, around the end of the second round, and a lot of things going haywire sort of after that. This process really does represent something meaningful and substantial, and obviously it's a court process, and Fair Share has been involved in all the cases, but so have a lot of special masters and a lot of folks who are representing the various municipalities and a lot of developers that are involved. And so I think from like a statewide perspective, I think it's it's something important to keep in mind and hopefully celebrated. As far as kind of, sort of going on down the line where we are now, as I said, there's really one case that's unresolved. And then we have, one of the things that we've seen more recently is sort of a wave of builder's remedy cases in towns that didn't file declaratory judgment actions. I've seen, probably, more than a half dozen so far this year, maybe close to a dozen in shore towns in Ocean County and Monmouth County, and in places that hadn't filed declaratory judgments. And so, if that's a warning out there to the towns that haven't filed yet, maybe there's some reason to try to get involved before a builder's remedy case is filed. And I'm not really sure why it's happening specifically in Monmouth and Ocean counties, especially in the shore towns, but that does seem to be a trend. Really during this process, Fair Share Housing Center has spent a great deal of time focusing on the towns that did file, and we really haven't had bandwidth to really go out there and file lawsuits or take any compliance actions against towns that didn't file, unless for whatever reason they were doing something particularly problematic, which there are a few, but for the most part, we've been focused on the towns that did file declaratory judgments. And so it sounds like there's some builders out there that are working in towns that didn't file. As I said, I think we have about 300 and somewhere between 340 and 350 settlement agreements. And I would say probably more than 2/3 of them have already reached a final judgment of repose. And so there's probably about maybe 100 towns out there that are still working on various compliance issues. For the most part, it's pretty, it's literally just tying up loose ends. We have a few, where we have more substantial things happening, but there's a lot of, I think it's a sort of a downstream effect of having so many of the same people involved in these cases that, there were just some things that got overlooked early on. And so we're sort of doubling back right now and going back and finishing up a bunch of the cases. And so my expectation is so we're at 100 right now, somewhere around 100. My expectation is probably by the end of this year, probably another third or so of them will be closed out before the end of the year, or maybe more than that. Sort of moving on to where we are right now. So I just talked about where, kind of how this process has played out. Where we are right now, at least from Fair Share Housing Center's perspective and what we've been working on, along with the compliance cases that I just mentioned, we've also spent a great deal of time, especially over the last year, really focusing on really monitoring and compliance, and also enforcing our settlement agreements. We have a number of different ways where problems can come up. We have a handful of towns where we have settlement agreements, and shortly after the agreement was signed, the town, for whatever reason, is just trying to either get out of it or trying to find ways not to comply. Probably the biggest example of that is this case in Englewood Cliffs, where we it's currently up on appeal, and we're currently awaiting an appellate division decision. And I'm not naming names just for the sake of it. I want people, if folks want to go and look into cases to try to see what's going on, and if you're advising clients, I want you to have some specifics on what you can look out for. We also have a number of cases where we have towns that have settled and have received final judgments of repose, and then have taken, for whatever reason, have taken actions that are inconsistent with that judgment of repose. And for that, I'm talking about, there are a number of towns that, where maybe the board and the municipality the governing body weren't on the same page, the planning board. And so the planning board denies site plan approval to a site that's in the housing plan. Obviously, that's a huge problem, and that's come up in a number of different places. Probably the most recent example would be in Mine Hill. If folks want to take a look at that, there's a recent decision from Judge Hansberry reversing the board's denial and appointing a special master and Mount Laurel compliance monitor to make sure that things are followed, that the agreement is implemented. And then lastly, we have a number of different cases, either with the midpoint review, what I would say is sort of under the umbrella of the midpoint review, and maybe also monitoring changed circumstances in certain towns. And so probably the most prominent example of that right now, I would say, is a situation involving Morris Township right now, where it appears that somewhere in the neighborhood of 80 acres has now become available in a town that took a vacant land adjustment. And so we're litigating over really what that means and how to deal with those 80 acres. And we're working on that now. And I think at this point, I'll ask, I forget who was going to be responsible for putting things into the chat, but I did have two handouts that I wanted to include today. And they are both appellate division cases. I think both important, and both have some interesting things for folks to take a look at. So the first one is this case involving the township of Bordentown. In that case, Fair Share Housing Center has a settlement agreement with Bordentown, and there was an objector to the settlement agreement who was unhappy. The practical thing he was unhappy about was that his site was not included in the plan. He's a developer. His legal arguments were that there was, inadequate process. He wasn't permitted to submit testimony that he wanted. He had some complaints about things like rental bonuses, and then he also had some complaints about the use of a special master in the case that all simultaneously serves as a municipal planner in other places. And so we have this opinion is attached. The interesting thing about this is really the first time that the appellate division has had a chance to analyze the fairness hearing process that we utilized in this Mount Laurel 3, post Mount Laurel 4 process. Really where the appellate division was analyzing the agreement and a process where a town settled with Fair Share Housing Center, and then we went to a fairness hearing. So I think it was a significant opinion. The appellate division published the opinion, so it has precedential effect. And I think they really went through and did a very good job of sort of explaining the process and sort of verifying the process that we've really all been using for the last 6 or 7 years in trying to get these agreements approved by the court. Some of the more substantial things that were in the decision are, I think, a validation of the use of a special master that also simultaneously serves as a municipal planner. It seemed to go without saying to me, but obviously we have a lot of folks who are qualified to be special masters in these cases, whether they've gotten their experience working for towns or working for developers. And obviously you wouldn't have that kind of qualification unless you actually worked in the business. And so I thought it was helpful that the appellate division sort of dealt with that head on. Separate from that, there was also some discussions about some of the various compliance mechanisms like rental bonus credits and some other things that COA had signed off on. You should definitely take a look at the decision. I thought it was helpful and was a good sort of roadmap through this Mount Laurel 4 process. The other case, I'll probably spend some less time on this one. The other case is a decision that came out a week or so ago in Fair Share Housing Center's longstanding longstanding litigation involving the city of Hoboken, where Fair Share Housing Center is challenging the approvals for 4 different developments where we've alleged that the developers are required to provide affordable housing units in accordance with the city's then in place mandatory set-aside ordinance. And we've now won at the appellate division, I think 3 times at this point. Decision in 2015, another one I think in 2020, and then there was one that just came down the other day. The most meaningful part of this, I think, for the folks on this panel and in this webinar, one of the arguments that the developers raised at the end, sort of at the end of the briefing, was an argument about whether or not the municipality could continue to impose a mandatory set-aside even after they had already addressed their or satisfied their 3rd round affordable housing obligations. And the appellate division said, yes, of course, Mount Laurel is a floor, it is not a ceiling. And so what that means to me is, so there's lots of towns out there that we've settled with over the years that have implemented their 3rd round plans. In many cases, you may have already constructed your entire fair share. And if you have a set-aside ordinance in place, you should continue to enforce that because, and you should feel confident in enforcing that because of this decision. Because, well, for starters, there's going to be a 4th round, and you're going to probably need some credits to go towards the 4th round. But I think it's important to make sure that we continue to get affordable housing constructed, even in towns that may have already addressed their 3rd round fair share. So take a look at those 2 decisions. I thought they were both pretty helpful. I'm not sure where I am on time. I'm assuming somebody's going to wave at me if it seems like I'm going too long. I guess I'm gonna skip one section. I feel like I am going a little long. So the last thing that I would say is sort of just looking forward to the 4th round. Obviously, Ed mentioned that earlier. We're 3 years out from the 4th round. I think everybody's wondering the same thing, which is, are we going to wind up in a process where there's a reinstituted COA, or are we going to be before the courts again, or what is this all going to look like? I certainly don't know the answer. I don't have a crystal ball, but my expectation is that either way, I think the 4th round process should be considerably simpler than the 3rd round process for a few reasons. One of which is that there will hopefully not be a so-called gap period where we have some large period where we're all in limbo, and so we just won't have to think about that complicated question. I think sort of piggybacking off of that, the period of need that we're going to be addressing in the 4th round is going to be 10 years rather than 26, because hopefully there won't be a gap period. So the obligations will probably be smaller. And then I also think that we've worked out a number of different issues during this 3rd round process that we just, hopefully aren't going to need to repeat during the 4th round. That's sort of my expectation. We'll see where things go. I'm going to stop talking now because I feel like I've gone on for a while, and I will let Ed introduce the next person.
Hi, just before Ed introduces anybody else, I'm going to place a poll on the screen. And just as a reminder to folks, there'll be polls throughout today, and you should answer them so that you can get continuing education credits. I'll leave that on the screen for about a minute.
Okay, hopefully you've been able to answer that very difficult question that we posted, but to guarantee that you're with us and you will get your credits. And Josh, thank you very much for getting us up to date from the Fair Share Housing Center perspective. Our next panelist today is Christiana Foglio, and we're really, really thrilled that Chris has made time to participate in our webinar. Chris is, I would call her kind of a rock star in the area of the delivery of affordable housing, state of New Jersey. She founded and is the president and CEO of Community Investment Strategies back in 1994, after her service as executive director of the New Jersey Housing and Mortgage Finance Agency. So she has a tremendous amount of experience in assisting developers and municipalities in delivering affordable housing and complying with their obligation during the third round. And hopefully she'll hang around and do it for the fourth round. Chris, it's all yours.
Thanks, Ed. And I think you have to put me into the old industry category, and definitely a fan of Fleetwood Mac. So I had a nice little chuckle when you did your introduction. So what I thought I'd do is we throw around a lot of different categories of what affordable housing is. I know that a lot of people on the panel know these components. So what I thought I would do is bring them up and maybe talk about some of the hurdles or new challenges that we face as we look at these different categories. So Mike Ossiani, who's on the call, is going to be assisting me. I have learned to have a millennial always available when you're doing any kind of tech presentation. So, you know, words of wisdom here. So Mike, let's go to the next slide. Okay, this is a mixed use redevelopment that CIS did in Lawrence, New Jersey. And I bring it up because I do believe as we are in a post-pandemic world where retail has suffered, municipalities are now refocused on economic development and how to strengthen either downtowns or areas that may be mixed use. I believe we can look back to projects that we may have. This project is close to, it's 10 years old. And what has happened is it's 68 units of senior housing in a corridor that has lacked investment over time. It is now coming back a little bit. It's alternate Route 1 for those people that know Mercer County. But I usually use this as an example of what you don't see is what's across the street. And across the street is a family-owned diner that was struggling to stay on, you know, point and stay open. And here we come with 68 senior units. So although we're meeting an affordable housing obligation, this I think is a good example of how we put people on the street. And in this particular case, people in the booths for the Blue Plate Special or Early Bird Specials, and actually was able to use affordable housing as an economic development tool. So I believe as we look forward and people are struggling with some of the post-pandemic economic impacts, affordable housing, which a lot of people don't think about as a component of that strategy, may make sense to municipal planners and you know, affordable housing committees. So we can go to the next slide. This is a municipal sponsored project. It's in development. It's in Haddonfield. I think this is the poster child for a lot of what we've all survived through. I think CIS was designated the developer 17 years ago. We are just starting to do the development. Now, this is a small development. It's on municipal land. The municipal land's behind the city hall. And it actually, you know, did help Haddonfield kind of keep the costs down in terms of doing this development. We're one of the first projects to submit under the DCA small projects program. And I thought I'd talk about, I think it's a terrific program. It allows for some of these small infill jobs, 25 units or less. But it has some hair on the program that I think, especially as we look to round 4, as Ed, said, the numbers may be smaller. We may be looking at smaller jobs to meet those obligations. There's some nuances to the DCA program that I think people need to know. One is that the DCA program requires that there be hard debt on the project. And for those of you that are involved in the financing side of the projects, small projects have a very difficult time securing debt. And the policy at the HMFA right now is that they don't provide debt on projects of 25 units or less. So why is that so critical? It's not just can the project afford the debt, it's that you don't have the option for a tax abatement just by virtue of using DCA money like you do when you have an HMFA mortgage. So if the HMFA mortgage program is cut off from this program, you only right now have the long-term tax abatement statute, which for small deals, you're asking a municipality to go through a full redevelopment process, which many are not willing to do. We're faced with this in a small deal that we are trying to get done in Hoboken. We have no vehicle for a pilot, and it really makes it very difficult for these numbers to come together. So I do think, and I want to put kudos out because I know people worked really hard to come up with this, the money to fund it and the program, but we really need to focus on how do you make it usable for communities. Right now, it's still cumbersome. The next project is what we all know as the inclusionary deals. CIS has been fortunate to work with a variety of market rate partners, Toll Brothers, K. Hovnanian, a variety of others. I still believe that inclusionary will really be the push in terms of a lot of the settlements. I don't want to speak for Fair Share, and I do have to throw them kudos. As a former chair of COA, it's pretty amazing how much they have accomplished in terms of really getting teeth into our Fair Housing Act. So thank you for what you're doing. This is, I believe, one of the better examples of when inclusionary goes well. It's actually inclusionary, but each section stands on its own. So we do have 100% affordable. That's part of the program. We use 4% credits. But what I like about it is that there is, you can see kind of to the left of the middle of the screen, Flanders Park. And the park really is the community component that pulls these sections together. So when I have visited, it's Marverland Crescent, the property, very North Jersey for Southerners that don't know where Flanders is. But what's really very cool is that the park has brought children from both sections to this community park. You really don't have the them and us mentality in this community. And I know that there's always a debate as to whether or not a 100% affordable, the segregation of 100% affordable can accomplish the feeling of being inclusive in a community. I do believe that in this particular instance, we were able to get the best of both worlds, being able to produce the units with the 4% credit, but not really give up on the idea that the community must feel inclusive to the families that live in whatever section that we're building. And I think it was just very fortunate that we had a beautiful municipal park that's completely programmed by the municipality. The next slide is a 100%, 9% affordable deal in Plainsboro. What we're seeing, and so, I think we all know the competition for 9% credits. Here, I wanted to talk about where the 9% credit program kind of stands as we sit here. CIS was incredibly fortunate and had 3 awards for 9% credits in the last round, only to find that as we proceeded to move through closing and get all of our permitting, 2 huge obstacles stood in the way, or is standing in the way right now. One is the new DEP rules. And I think this is something that we really need to pay attention to. You know, I have spoken to Fair Share about the issue, especially facing towns that have signed inclusionary developments to meet their fair share obligation. Some of those developments, if they have not proceeded and secured the level of permitting and approvals to grandfather them, will have rules that could impact density yields. The density yield then will flow down to putting pressure on what and how much affordable housing can be built. So for individuals that are representing municipalities, I really strongly suggest, you know, a call out to developers that are sitting with the inclusionary obligation to figure out where they are in that process. Are they envisioning some impact to their density yield, so that you're prepared if there's a loss of units? The other big item is, as everyone knows, the interest rate. And I know that Debra Urban's on, and I'm sure she's going to talk about the HMFA, who's really the true financial partner for all of these projects to be built. But they were forced to raise their interest rate by a full point within the last several weeks. So for deals that went into a very competitive 9% round, you know, I think everybody knows that these are really tight budgets, and a mortgage interest, you know, full point on a mortgage interest rate really starts to erode the financial viability of a deal. So those are 2 that I think are really critical to look forward in terms of how we're going to deal with outside pressures that are of no fault of the developer, but still, you know, generate a tremendous amount of more challenge to getting these projects done. And then for the municipal people, you know what happens. The developer, you know, winds up at the municipality's door, which I have done as a good developer. You know, I'm sure if there's any of my municipal friends out there, they're like, oh, she's not shy of coming back. But it truly is unfair to have to come back to the town when they think they have solidified a deal and we've all celebrated a 9% award, only to find out there's $1 million bust in the numbers just from the interest rate. And that's pretty much a killer. Okay, Mike, the next one. This is in Glassboro. It's Whitney Crescent. And the reason I chose this, although it's, you know, still the same kind of 9% structure, is that this was addressing a problem project for the town. This had been an existing rental project that really was just not a good partner with the municipality. It was a project where, let's say, the not so great landlord, you know, was in the habit of charging people to, like, you know, fix their toilet, and just not really good and not really well maintained, and creating not a fair or quality housing for affordable, for low income people, and also just wasn't a good product or neighborhood to be part of the fabric of that community. So I brought this up because the idea here is, as people struggle to see, you know, where do you put this housing? And if there are old, not nice, not, you know, it doesn't meet the real benchmark of quality housing anymore, I really do believe, as we look forward to the 4th round, is repositioning existing stock, or looking at strategies of preservation. So I do believe that that's where we're going to see some new opportunities in order to meet obligations that come out of the 4th round. Okay, Mike. Bayshore Village is a 4% senior community in Middletown. you know, everybody loves a senior job. And, you know, we are able to rehouse individuals that may have to leave a community because they just can't afford their homes. We all know that. So the challenges here, as we look at, you know, doing senior communities, continue to be more of an economic issues that are facing us. The cost of, you know, supply chain issues that continue to impact projects, as well as seniors that actually are over income in many of our suburban communities. That's why I think, and I think Deb knows, that the development community would like to see an opportunity to, you know, use some more of the blending kind of income opportunities that the tax credit offers, so that we could capture some of those seniors that are above 60%. In many of our suburban communities, our seniors, our retirees have pensions, and by no means are they wealthy or can't afford real market rate rents, especially as we look at what happened in New Jersey to market rate rents, but they're just not poor enough to get into the housing. So we do have a huge gap of unfulfilled need in the senior community. So I wanted to mention that. This is a projected project, and I think it goes to a lot of the struggles that many communities face. Morristown is a fabulous community, has agreed to a settlement with Fair Share, wants to be a good guy, but, you know, got land. But we just could not get the points, just do not qualify under the existing point system for a tax credit project. And so we worked really hard with the municipality to see, like, how could we make this work for them. It is eligible, this particular location in Morristown is eligible for the New Jersey Aspire program. But I'm going to be honest, the New Jersey Aspire program is a joint kind of program run by EDA and HMFA. It's cumbersome. We're not sure exactly how it's going to work. We're not sure that there is a market for the New Jersey credits that a project can receive under the Aspire program. So I think it's to be seen whether that's going to be a realistic vehicle we're going to continue to pursue. But I'm not going to take Deb's thunder. I think there's other programs for communities like a Morristown that can't qualify under the governor's announcement of the 300 million. And I'll defer to Deb for more information on that. But we're watching Aspire, where Aspire really can only be used in larger projects. Doesn't work for any of the small projects. You're not going to meet the minimum thresholds. Aspire, though, does create prevailing wage obligations. And that was the other topic I thought I could address. Prevailing wages becoming a huge issue in municipalities. Obviously, depending on the source of funding that you take, if you take HMFA's construction financing, it will trigger prevailing wage. If you now use the New Jersey Aspire program, it will trigger prevailing wage. But one nuance of prevailing wage that I think some people are not aware of is when a town does purchase land and is making that land available to a developer, if the town wants to retain ownership of the land, even in a long-term 99-year lease, even if it's for $1 a year, the ownership of that ground will trigger prevailing wage in a project. Overall, 28 to 30% increase in your construction costs. And I think it's really important as you put these components together to understand that that kind of impact will just make the project, you know, that much more expensive. And if it is municipal sponsored, there is going to be a cost associated for additional funding. The 9% program is not going to cover all of those costs. So you are looking at a contribution through the Affordable Housing Trust Fund or some other soft money. So I think I think that those are really some of the big hurdles that we really need to think about as we look forward. One issue that rarely is brought to the attention of the participants in this is the relationship with syndicators. And I have to tell you that the industry has shifted tremendously over the, hate to say it, 30 years that I've been involved here. And the syndicators and investors that are buying these credits are now looking at affordable housing as a value asset class. In the past, it was done for only CRA. It was that they would get, in a 4% deal, they would get depreciation, they would get the CRA credits, and they would get the tax credits. What is happening now as we start to negotiate our financing with the syndicators who bring equity into the project, they are looking for back-end value. So there's a tremendous amount of pressure on the developer to agree that there will be a financial exercise at the end of the 15 years, because most of these investors will exit in year 15, and they want cash out. In the past, we would pay their exit taxes and they would leave. That is not the case anymore. And we spend a tremendous amount of time negotiating not to have to pay a huge amount on an exit strategy. Now, why are we doing that? Because in year 15, we're going to have to put additional debt on these properties in order to pay that syndicator to leave. Why is it important to a municipality? If you place a deed in perpetuity, if you add items that limit the valuation of the property, we are going to have a very difficult time negotiating with investors. I know that we've brought the issue up to HMFA. States across the country are dealing with this. We're hopeful that there will be maybe some new language in the next QAP, which holds syndicators' feet to the fire, and try to limit the impact that they're having on really trying to keep these units operating well, and available to the community for the 30 years at a minimum, and beyond the 30 years when we sign extended use provisions. On the deed restriction side, I do have to kind of argue a point that I have with in perpetuity deed restrictions. One of the big issues is that when you look, and I know Ed said we're only looking forward, we're not looking back. Oh, perfect. Sorry, I've got to shut off my phone. Not looking back, but in the history of all of the programs, including current programs in preservation at the HMFA, you have to show for new funding to come into those existing inventory, the issue of loss of affordability. If you do a deed in perpetuity, you're really limiting the project to going in for additional money or recapitalization in year 15 for new roofs and updates. And I'd like to say that the reserve for replacement is going to be able to fund everything, but honestly, that's not the case. So when you do the deed in perpetuity, you really are limiting, in some cases, the ability long-term to reposition from a preservation strategy. And, as we are making headway in building these units, I think one of the priorities is what tools are we also providing for preservation. And so I would alert people that those deed in perpetuities are very difficult to then reposition a deal under. The other issue is tax abatements. So tax abatements currently can only go for 30 years. When you add those additional years, there's no ability to secure the abatement. I know there's been some change to the pilot legislation at the state, which allows us to come back in and say it was HMFA financed, it did have a pilot. The town then has a right to extend that pilot, but it's still a political function, and you're still putting the municipality in a position that they have to politically award an extension of a pilot. If they don't extend it, your taxes will go to, regular taxation, almost impossible for the affordable housing to operate and pay what could be, triple the rate of the taxes at that time. So those were my highlights of things to think about, things to come, and I'll turn it back over to Ed.
I think we also have the next stop point here to make sure you're still in attendance. So if you could take a look at the question and answer that question, you'll get your credits. And Christine, thank you very much for giving us that roadmap for the financing challenges now and going forward. I suspect they're going to be with us for a while. And I was also thrilled to have somebody else on the webinar that knew who Fleetwood Mac was. I mean, that to me is a real accomplishment. I thought I'd be the only character that could relate to that, but thank you. You made my day. Lindsay, do we have to wait for this poll to be answered before we move on?
You can go ahead. I'm going to close it in just a few seconds.
All right, great. Well, while we have the announcement blocking out Debra's picture, we're going to introduce Debra Urban. I have not had the pleasure of meeting Debra, although I've heard about her reputation as the brightest lawyer in the state of New Jersey who understands tax credits. And I think Chris laid the foundation for some of the financing challenges. And I think Debbie now is dealing with those. Chris mentioned how the interest rates have just, for all of us, and particularly your program, has just jumped up dramatically. So Debbie, if you could kind of make a forecast of where you think we may be going for the fourth round and what some of the challenges might be in terms of financing the projects that have to be built. It's all yours.
Thank you, Ed. I appreciate it. Good morning, everyone. And I just wanted to thank you for allowing me the opportunity to participate on this panel. I think both Josh and Chris provided great segues into the topics I'm going to be discussing today. I completely agree with Josh that from the agency's perspective, we have seen this as the, largest time and opportunity where there has been statewide broad-based compliance and willingness to move forward with the settlement agreements. And obviously, the agency is taking an active and integral part in making those projects come to fruition and bringing them to the finish line via our financing instruments. I think Chris's presentation also brought to light that fact just by virtue of the projects that she was discussing and giving examples on, all but one, which was that the small project did receive, I believe, agency assistance either through our financing and or our 9% or 4% tax credit programs. So really, like I said, that's our job, is to try to bring these projects to the finish line. And while I was on a panel last week at NJ Future that was supposed to talk about the state of housing in New Jersey, and the one word that I use to describe it, which I'm sure all of you would agree right now, is challenging. So while we do have our typical vehicles to provide assistance, they, as Chris has brought up, might not necessarily be enough given our current situation. But in any event, this might be a repeat for some of you, so I do apologize. But I will start from the basics and then talk about some of the more nuanced forms of assistance that we're trying to provide. Of course, the largest form of assistance that we have, as was previously discussed, is our 9% low-income housing tax credit program. This program, we actually have our upcoming round. The applications are due August 31st, with awards expected by the end of the year. For those of you who may be contemplating an application for agency financing in order to be submitted as part of that 9% application, I just wanted to give an update administratively that originally the submissions to our multifamily staff were due, I believe, June 23rd, or I'm sorry, maybe next week or late June, but we have extended that deadline to July 6th to provide for more opportunity for preparation. So I just wanted to make everyone aware of that. And again, that's only if you were looking to get an agency conditional commitment to include as part of your 9% application submission. The QAP itself, as you know, the tax credit program is extremely competitive. Typically, we see a 3-to-1, 2-to-1 demand to supply. So our rules have had to become more competitive, more complicated. But fortunately, we are able to incorporate into that our priorities in order to ensure that the type of housing that we're seeing is really the goals of the state that are also achievable by the development community. And one of the priorities that we have had for the past several years is obviously a commitment to providing housing that meets fair share settlement agreements. And one main example we have of that is the split that we have with respect to our allocations. Right now, at a minimum, we do require that at least 60% of our 9% awards go to non-TUMs, which are areas outside of a targeted urban municipality. And so those typically end up being our settlement agreement projects. And so we are very fortunate that we have had no problem in meeting that 60-40 split. And in fact, this past year in 2021, our awards were skewed even more so just by virtue of the applications we received. So I think it was actually closer to a 70-30 or 75-25 split. So that has gone a long way in helping to assist current obligations. Besides the 2022 round that is coming up, obviously we are looking forward towards 2023 and beyond. And as Ed said, addressing future obligations in the fourth round. And to that end, we are in the process of amending our rules for the qualified allocation plan that is in a regulatory format. So obviously we'll go through that process of a public comment period, public hearing, et cetera, before it's finalized. But in the interim, prior to that formal process, we are also very open to preliminary comments right now and feedback as to what concerns might be. We always want to make sure that we're responsive to the development community and of course, achieving the goals of the administration and the housing needs of the state. So again, we have had roundtable discussions with a lot of our industry participants and development partners and housing advocates. And to the extent that anyone here on this meeting has additional comments they'd like to provide as to how we might improve the QAP, please feel free to send them my way or to anyone at the HMFA staff that we can certainly take them into consideration. A lot of the points that Chris has raised during her presentation are areas that we hope to address as well. By way of example, repositioning current stock of or creative ways to continue to meet affordable housing obligation given scarcity of land and other resources. And so preservation strategies is one thing we are looking at. While we do have a set aside right now for preservation housing, to the extent that we can increase that priority, we are looking to do so. In addition to that, the exit strategies and the concerns that Chris had raised regarding syndicator roles and more active participation on the back end. We are also looking to, similar to other state HFAs, have greater oversight on that back end exit strategy. So again, trying to be responsive to the needs and the concerns that have been raised by our partners. We are looking to make those changes in the next year's QAP. While the 9%, again, is the most valuable tool we have, it is a limited resource. It is a credit that is in huge demand given the amount of equity that it generates for a project. And so, of course, to that end, it is definitely not enough to meet the needs of the state. And so the, I think, second most vital resource that we have at the agency is our 4% tax credit program, which is combined with our volume cap and tax exempt financing. Again, the disadvantage of that program, unfortunately, is that it does not raise as much equity as the 9%. And so it does require a larger infusion of subsidy, whether that be from the local level or other state or federal resources that can be obtained. And with respect to that, that is why the governor's current budget proposal of $300 million roughly of ARP dollars to assist in providing gap subsidy is vital to ensuring that the third round obligations and the backlog of those can be addressed prior to and in anticipation of future fourth round obligations. And so we are very excited for that proposal and grateful to the Murphy administration for that support and that recognition of that need. Again, it's about $305 million that is currently being proposed from the federal ARP dollars. And right now, the proposal is to dedicate it towards 100% fully affordable developments that are part of approved settlement agreements. So we are very excited for that proposal and how much it can do to address the current backlog, as I said. And on top of that, obviously, it has a ripple effect because while those types of projects that would typically apply to a 9% round, and unfortunately, due to the limited resource of the 9% credit, sometimes have to wait 1 round, 2 rounds, 3 rounds in order to finally get funded. To the extent we can now address those projects through the 4% program with sufficient subsidy, we anticipate that would free up the other resources, including the 9% credit, to address other priorities of the state, whether that be supportive housing, preservation, as I mentioned before, and also mixed income urban development. And so it really is a win-win situation for both urban and suburban communities to the extent that that proposal is passed. One area that I wanted to mention with respect to that proposal is to the extent that we are able to obtain that funding, it is anticipated that roughly 3,300 units would be supported by those dollars. And so obviously that goes a long way in meeting municipal obligations. One item I did want to clarify is I know a lot of people have heard talk of a list or the list of projects or towns and settlement agreements that would be assisted by and aided by this funding. Just a clarification, that is not an all-inclusive list. That is not an exhaustive list. That is just a list of known projects or known municipalities that have successfully gone through the settlement process or have executed settlement agreements. And so we anticipate those are the types of deals that would be assisted. That does not mean that there aren't other projects, other towns out there that are similarly situated and could benefit from these funds. So the process, hopefully, if those funds are awarded or passed by the in the budget, would be a very similar process to any of our financing programs. It would be an application submission to the agency, readiness to proceed criteria to be reviewed, because the ARP dollars, similar to any other funding source we have, has timeframes within which to expend those dollars. And so readiness to proceed is a huge factor that we would take into consideration in awarding those funds. So again, just a clarification, because I know, we get questions now and then about the list. So just wanted to make that clear. Again, those are our 2 main vehicles. And as Chris pointed out earlier, while they go a long way in helping to finance these deals, they unfortunately in these challenging times have not necessarily been enough to get people and projects over the finish line. We, once a 9% award has been granted, historically, we don't see those deals until the project's placed in service and asking for their tax form 8609. More recently, that has not been the case. We hear from them much sooner, usually prior to closing, because as Chris said, whether it be supply chain issues or construction cost increases, and now unfortunately rising interest rate environments, They are experiencing funding gaps much sooner and much more often that can't get them to the closing table. And so in response to that, the agency and the Murphy administration has been trying to come up with creative strategies to address that. One example of that is the Affordable Housing Gap Subsidy Program that was created and instituted here at the agency. This was a $40 million fund, also from the ARP dollars, that was designed primarily for previously awarded 9% tax credit deals. It also is open to 4% and other types of state-funded projects, but the main priority was the 2019, 2020 deals that were funded by 9% awards. And again, just couldn't get over that hump to either close or finish construction because of significant cost increases. And so 40 million was made available to these types of projects as an additional resource to fill those gaps. We are in the process of reviewing those applications. It's not a competitive process, but it was a cycle that they did have to submit for. And so we are in the process of reviewing those and hope to be able to present those to our board very shortly. In addition to that, we do have our conventional forms of relief that we have provided in the past as well, which are our hardship credits through the 9% tax credit program. And that, again, just for unforeseen circumstances, allows projects to come back in and apply for an additional allocation of credits based on the changing circumstance that is unforeseen to them. I think that really covers everything I wanted to say. Just looking through my notes right now. I think that's it. So I will turn it over to Ed, and of course I'm available for questions and appreciate the opportunity to participate.
Well, Debbie, thank you. I think you and Chris back to back have really explained and stressed the importance of coming up with financing, obviously going forward for the remainder of round 3 and into round 4. And just a heads up for the administrative agents, the municipal administrative agents who are attending today. We have about 60 attendees, and I think a number of them are AAs. But make sure that your municipality is being diligent about collecting your affordable housing development fees and putting them in your trust account. I know a number of these projects get kicked ahead if the municipality has a substantial contribution they can make, particularly for the 100% affordable program. So it's all about money, and it's going to be that way for the 4th round, I'm afraid. So keep your eye on the ball. We have one final poll. I guess everybody is asked to complete so that we know you're in attendance. But I think Lindsay said we could move on to our final participant. And we thank very much Beth McManus for being available. Beth is a principal in a relatively new firm that she and Jim Kyle set up, Kyle and McManus. She is a seasoned professional planner. She has served, I think, over 40 court cases during the 3rd round. And the best thing about Beth is she's got the nicest manner that any planner I've ever met. And you need that when you're dealing with these municipalities that many of us represent. And Beth has that ability to bring both sides together when they don't want to be and resolve the difficult cases. So maybe Beth can, hopefully she'll hang around for the 4th round. I hear a lot of the professional planners are bailing out before the 4th round, but Beth is just a kid. So I think we got her for a while. And maybe you can tell us, Beth, what you think is coming in the 4th round.
Thanks, Ed. That's very kind of you. I think I'm the closer, so I'm going to talk a little bit about what I think towns can do just to finish out the 3rd round and what they can do to ready themselves for the 4th round. So first and foremost, in terms of the 3rd round, conduct your annual monitoring. And yes, it's required in just about every settlement agreement, and that reflects what we already see in COA's rules and also what's required by the Fair Housing Act, and that includes your unit or your program monitoring, plus your very low income monitoring, plus your trust fund monitoring. And so while that's certainly important for fulfilling the terms of the settlement agreement, it's also important because it confirms that your affordability controls were applied properly and that they remain in place for older units, that the units were, or rather are being developed properly and with the appropriate bedroom and income distribution. And that's important because simply put, just because a development has a condition requiring compliance does not always mean that it will be compliant. I think there are a lot of developers out there that are eager for approvals and are eager to say yes to just about any condition, and perhaps without fully understanding exactly what that requires of them. And then lastly, for trust fund expenditures, that monitoring is important because it is going to help you confirm that you're not going over that 20% administrative cap. It's going to confirm that you're meeting your 30% affordability assistance. And also it's just going to confirm that you're on track for creating the affordable housing units that are set forth in your settlement agreement, as well as your housing element and fair share plan. The second thing for the third round, and perhaps most obvious, is implementing those programs, but including advertising. So advertise those rehabilitation programs, especially the municipal rental rehabilitation programs that so many municipalities are tasked with implementing and maybe new to them in the third round. Also advertising your accessory apartment programs. There are several towns out there with these programs. They're, I think, notoriously difficult to generate interest in. So keep efforts up to advertise those units to make sure you're capturing any household that might be interested in creating one. And then obviously work to see your 100% affordable housing projects are funded and developed, work with developers of your inclusionary sites throughout your plan. Also, continue to seek out opportunities for market to affordable, and perhaps also in ways that are not necessarily expressed in your housing element fair share plan. It may be a way, for example, to address vacant home concerns in the community. Be on the lookout to extend affordability controls that may or may not be in your settlement agreement, but doing so can only be a good thing, since you'll certainly be continuing to expand the availability of affordable units in the municipality, but also you may be generating credit for your fourth round obligation. And these tasks, I think, are generally split between the administrative agent for the community and the municipality, but I would encourage folks to talk with each other and see how they can best do this implementation or the advertising. But once your compliance is done, once you've maybe gotten through this big push of work, this is probably a good time to review your changes and determine what else might be appropriate. So in some communities, meeting that obligation required significant changes in zoning. And so this is an opportunity to sort of take a step back and see what other improvements or policy changes are necessary to support what you did to meet that obligation, and what could be necessary to better get ready for that fourth round obligation. So some of the big concerns municipalities and the public have expressed during this process are circulation concerns. So this is an opportunity to take a look at traffic volumes, our road improvements, or other types of improvements needed to address the incoming residents. So I'm thinking not just about improvements for personal vehicles, but also walkability, sidewalks, bikeability, as well as improvements to better support mass transit. Additionally, think about parks and recreation. Now that you've provided zoning to accommodate new residents, are additional park and recreation areas necessary? This is a great time to start thinking about that. Similarly, think about infrastructure for sewer and water capacity, and infrastructure for stormwater and flood control. And in terms of zoning, many settlements resulted in a change of character to the community or parts of the community. So if you think about the office or retail sites that might be developed with inclusionary housing, I think there's a good question to ask is, are adjustments necessary to the surrounding zoning? So I can imagine areas with new inclusionary housing might also permit incompatible uses. I'm thinking about warehouses and maybe other industrial uses. Or perhaps there are other zoning changes necessary to be more appropriate for being adjacent to residential uses. So I'm thinking about buffers or maybe other site design standards, like something as simple as lighting. They may need to be adjusted to accommodate the fact that these uses are now going to be adjacent to residential uses. And additionally, maybe retail or service uses or districts are now needed to better support new inclusionary housing residents and to better support their quality of life. If you're creating new residential neighborhoods, it's worth considering whether or not a small service district might be necessary or a good idea to better support those residents. And I think these are great topics to address in an updated master plan re-exam or perhaps another master plan element, but it may not be necessary to create these new documents in order to start thinking about and perhaps addressing these concerns. And the last topic I wanted to touch upon is recognition that that fourth round is just 3 years away, or just 36 months away, as Ed so kindly reminded all of us. And that time is going to go very fast. And so I recommend that any new townhouse or multifamily development include a set aside of affordable housing units. Now, frankly, that might be necessary, it might be required due to the mandatory set aside ordinance that the town was required to adopt through their settlement agreement process, but it may not be. But regardless, I think it's a really good idea to start getting ahead of that fourth round obligation by taking opportunities wherever they may arise. If you think about how difficult it was for some towns, for many towns, to settle and to meet that third round obligation, I think it's a great idea to start thinking about how we can begin mitigating what may come in the fourth round. Anything that we can do to get out in front of it is a good thing. And I'd hate to see opportunities for multifamily or townhouses be wasted in the affordable housing units that could have been generated by those projects not be created. And so consider also some of our struggling office and retail uses. I think we're all well aware about what's happening to the market for these types of land uses. And quite frankly, I think it's going to be a lot easier to negotiate with the owner or the developer of these sites, or what could be redeveloped sites now rather than after they've intervened in the fourth round. And so ultimately, my recommendation is that any potential for new housing should be viewed through the lens of Mount Laurel to see what we can do to try to mitigate those changes for the fourth round and just get a jump start on that obligation. And all of this is really extra important for vacant land adjustment towns, for which I think there are going to be a lot more of them come the fourth round. And so current vacant land adjustment towns should be asking themselves, will this new development or redevelopment generate RDP? And if yes, start thinking about how that obligation is going to be met. And so keeping these things in mind and taking care of these tasks are going to be really helpful in maintaining your third round compliance and setting yourselves up well for the fourth round. And so, like I said, these are just simply doing the annual monitoring that you're already required to do, and using that not just for the purpose of fulfilling the settlement agreement, but also really tracking your compliance. Doing that program implementation, including advertising of some of your smaller but still important programs. Taking a step back to see if planning or improvements are needed to address changes for the third round and what may come in the fourth round. And looking for, or at a minimum, making sure not to miss opportunities for inclusionary development. So those are my recommendations for what we can all start doing in the next 36 months. And thanks so much for giving me the opportunity to speak. I'm happy to answer any questions about this.
Thank you, Beth. I think you shared with our attendees some real good heads up about what you can start doing now with 3 years left to do planning before there's a lot of pressure to do planning. So I think that's a great segue into completing our seminar. We do have 10 minutes left, and we do have on the agenda a panel discussion with all of our participants. I don't know if Michael or Lindsay has, I see we probably have a few questions that have been submitted. And now we got
Yep.
another poll. So I guess you can answer that poll to make sure you're here. Michael, do we have some questions we can share with the panel and they can comment upon?
Sure, we do. And I just want to thank Josh and Chris for answering 2 of the questions that already came through in the Q&A. But we do have a couple additional ones. If you're ready, I can read through the first one now.
Sure.
So the first one is the idea that virtually every new construction tax credit project is seeking rehabilitation funds in year 15 suggests that we need to improve standards for finishes and materials. Unfortunately, the QAP's tiebreaker methodology seems to encourage developments to shave costs everywhere they can. How do we make tax credit projects more sustainable so they can reach the year 30 without refinancing or tax credit preservation funds?
I'm going to assume that one's for me.
All right, Debbie.
So a couple of points I just wanted to make with respect to this question. I wouldn't necessarily say that every deal comes to the agency in year 15 to seek additional credits. I do want to caveat that by saying that obviously the older housing stock, the older QAPs did not necessarily have as much of a focus on sustainability, green features, things like that. It was a much less competitive process back in the day. And unfortunately, I do have to admit that I was around back in the day. So I do know that the components were not as, I don't want to use the word onerous, but we definitely did not dive into the details of, like I said, sustainability and green building at that time. So that may be why the older housing stock or the older tax credit deals are coming in now, but I wouldn't necessarily say that would be a trend moving forward, knowing the types of green building that we're encouraging. I wouldn't say require, but it is in the point system. So basically everybody checks those boxes. And so we are actively addressing that is, I guess, the best answer. And also to give the heads up that we are looking to make additional recommendations and improvements in that area for the 2023 QAP. Chris, I think you wanted to add.
Yeah, of course, Deb. I mean, there's an open opportunity to comment, so I can't miss it. We would like the agency to also consider increasing the per unit maximums, because even with additional funding that a town, or if we were able to secure home dollars, we're not able to really take advantage of that because of the caps, and the caps have been in place for quite a while. And I think Deb agrees that we've seen pressure on the construction side more so than in the past, that may justify them at least evaluating it.
Yeah, now I agree. And the other piece that I did forget to touch on is, I know that the tiebreaker has been obviously a very hot topic with our developers over the years. And, obviously that is not, leveraging is the goal of that. And unfortunately, sometimes the unintended consequences, as the commenter stated, potentially shaving costs or reducing it to the extent possible. But we are not looking to have that goal be to reduce the quality of the housing. So we are also, as part of the 2023 QAP, looking at ways to still, encourage leveraging, but not making it the tiebreaker be the end all be all decision maker on who gets those credits. So.
Thank you both. Michael, we got another one?
Yeah, we have another one actually also about the funding programs. And Deb, I think you answered the first part of this question, but I'll just read through it. Can you address more specifically the status of the $40 million AHGS program and the $305 million ARP program, and why urban projects would essentially be locked out of receiving these funds if targeted to fair share settlements in the suburbs?
Sure, no problem. So with respect to the first part of the question, the 40 million gap subsidy, obviously that is something that everybody has been anxious, and including the agency, to push forward. We would like these deals to get done as quickly as everyone else would as well. And so we are working very diligently to get that done. There were some structural issues, frankly, on a nationwide level with how the ARP dollars could be most efficiently deployed with respect to affordable housing. And so, the typical ways that we finance it, essentially as a soft loan with a 30-year amortization. So there were some technical and structural issues that we had to work out with respect to that. I think we're very close to nailing that down. And so we definitely have seen more positive movement and more forward movement with those dollars in just the past month alone. And so we do expect those to be deployed in the very near future. And with respect to the 305 million, I know, I don't want to say stereotype, but, the understanding or is that, these are quote suburban type deals. That isn't necessarily, the case. Again, the goal is to address the settlement agreements, no matter what location they're in. So we don't necessarily feel that it locks out urban deals. Again, also by virtue of the fact that my previous comment that it actually opens up other funding sources that may not have been as available to them in the past, just by virtue of the fact of settlement agreement deals coming in for the same limited resources. So, these are known projects that we are known needs that we know need to be addressed in anticipation of the fourth round. These are projects that are already finalized with respect to settlement agreements and ready to go. And so to the extent we can address that need, get those projects out of the way and online in order to be able to address other needs in both urban and suburban areas through our other limited resources, that is the strategy that is anticipated and look forward to.
Great, thank you. We have another question here. I think we still have a few more minutes. So how will the fourth round numbers be determined and what will that process look like? And that could just be for all the panelists, anyone who wants to jump in and answer that one.
Yeah, I think I don't think we know. I think one of likely, one of three things is going to happen. Either A, there will be no legislative or administrative changes, and we will be proceeding with a fourth round process that will be in the courts, and it'll be, we'll still have the same directives that we had from the Supreme Court in Mount Laurel 4 that said use the prior round methodology. Layered onto that, we now have a few decisions from trial courts in the third round about how to sort of appropriately implement that. But, that's probably, that's one of the choices. The other, another choice is if we actually have some administrative action, either in a reinstituted COA or, something like that. And and in that case, it would be whatever the policy makers are doing, whatever choice they're making. And then I guess three would be if there's some legislative change, if the legislature, tries to do something a little bit different, maybe creates a new agency or a different agency. Those are really the only three things that I can think of. And, it's likely, I imagine, to be one of those three.
And this is Chris. I just wondered if I could just ask Josh a quick question. So Josh, in terms of compliance hearings for the towns, if towns, I know that you do a lot of due diligence at Fair Share in terms of there's a 100% affordable deal, you usually look at, you know, how will it be financed, how do the numbers go together, or if they're inclusionary. You know, you look for a lot of documentation. With the DEP rules kind of putting some of those projects in jeopardy of yield, or because we're facing these interest rate issues, do you think that, you know, how would you be advising towns, you know, if they're facing that, what they should be expecting in terms of the position of fair share? And then the third piece of that, as Deb, you know, mentioned, the HMFA is coming out with a source that wasn't available to municipalities maybe when they had signed those agreements. Would you be open, if they had a project that met that criteria for funding, to, you know, go after that funding?
Sort of answering, I think in reverse order. Yeah, I think, you know, we're very excited about this new source of funding, and you know, we realized that over the last 6 years that there have been a number of different sites that were included in fair share plans, and for the most part, they're ready to go, but for having the funding. And so we're, you know, it's a game changer, and we're very excited to have it available. We fully expect that, you know, it'll, you know, there's a bunch of sites that are ready to go, and I'm sure that savvy towns and savvy developers will hastily get some other developments together if there, you know, if there are sites that are out there. I'm sure I've already sort of heard mumblings and grumblings about some different things that are happening. So we are very excited about that, and you know, if there's one site that's in an agreement that's, you know, that's not moving forward, and we have another one that we can replace it with, I think that's certainly a conversation we're interested in having. Especially, you know, I think we've already done that a number of times where, you know, we're taking a site out that's been sort of languishing for 4 or 5 years and replacing with something that's going to move forward quickly. You know, I think we're definitely interested in having that conversation. As far as, you know, the other administrative changes with like DEP regulations and that sort of stuff, I think that's something that, you know, I know there's this, there's sort of more broad sweeping changes that are happening that are potentially going to affect some sites. You know, the only thing I would say to that is I don't think that is a, you know, we're sort of used to that to some degree. You know, usually more on an ad hoc basis, case by case. You know, the DEP reclassifies wetlands on a site, you know, and all of a sudden now there's 4 or 5 less, you know, fewer developable acres on a property. Now we have to figure something out. We've encountered that a number of times and found ways to work through it, either by redesigning the property, in some cases maybe with continuing to get the same unit yield, and in some cases not, and then we're, you know, depending on the situation, needing to go and find perhaps another site or two to make up the shortfall. You know, I think I'm not sure if that answers the question, but that's kind of where we are. I think, you know, obviously the towns have fair share obligations. I think we've tried our best to really scrutinize sites and take close look at sites, and, you know, make sure that, you know, if we can, you know, that we're not citing affordable developments in, you know, floodplains or other places that are going to make them difficult or impossible to get developed. You know, if circumstances change, you know, I think that you know, we're used to that, and you know, I think there's large recognitions for that in, you know, I think the Supreme Court, as far back as, you know, 1983, when it decided Mount Laurel 2, I think was keenly aware of the fact that things can change over time, and we have to deal with that. So I see the time to wrap it up signal, so I'm going to stop talking. I don't know if anybody has any other questions.
Thank you, Josh. And on behalf of affordable housing professionals, I'd like to thank all of our panelists today. You did a wonderful job, and I think provided a real service to the folks in the trenches working on affordable housing. And I'd also like to thank Mike and Lindsay for their support as well. Hopefully, we try to present these programs, which we kind of consider nuts and bolts programs, about issues that affordable housing agents may be involved with, municipal housing liaisons may be involved with. If you got nothing else out of the seminar today, you heard about the 36-month countdown. So go back to your towns. If you're a developer, dust off your plans and start planning now for the fourth round so that it's not a scramble like it was at the beginning of the third round. And I think you'd be well served to do that. And also, if you're not a member of the Affordable Housing Professionals of New Jersey, I'd encourage you to join. We're a pretty cheap date. And you'll also get notices about programs like this, which we will continue to present during the rest of this year, as long as we're around. So on behalf of the organization, I say thank you very much and have a great day.
Thank you, everyone. And if you could please take the survey that will pop up on your screen, that would be great. Thank you so much.